All right, I have 2 p.m. Eastern Time. I want to welcome everyone and thank you for joining us for today's briefing and discussion on FLA's lawsuit challenging the designation of critical habitat for the black pine snake. Everyone's line is going to be muted for the duration of the presentation. However, we will be taking questions at the end of the presentations. You may ask a question by using the raise hand function, and then your line will be unmuted, or you may post your question in the question and answer box at the bottom of your screen. I'm Scott Jones, the CEO of Forest Landowners Association, and I'm joined today by Dr. Lauren Ward, General Counsel and Director of Regulatory Affairs at Forest Landowners, and Katie Moss, the uh, Policy and Legislative Assistant for Forest Landowners. You'll also be hearing from the Pacific Legal Foundation, and we're joined by Charles Yates and Jonathan Wood. The Forest Landowners Association has been monitoring and working on the black pine snake issue, along with a lot of other partners and interested parties in the forestry sector since the proposed listing. So it's been quite a while. Our goal in working on this listing was to bridge a knowledge gap that we believe existed between U.S. Fish and Wildlife Service and private forest landowners, and to create a better understanding of the needs of private forest landowners so that we could avoid unintentional consequences and as a result of the listing and any of the rulemaking involved here. So we had multiple meetings throughout the years, filed a lot of comments. A lot of comments were filed by our members and partners, other partner associations. Um, During the listing time. And we had one of the meetings we had is the one you're seeing here on your screen. This is a forest forum that we held in November of 2015 in Pearl, Mississippi. So forest forums and timber talks are two programs that we use at the Forest Landowners Association to help us create a better understanding of private forest landowner needs. Forest forums we do inside, and timber talks we try to bring agencies like the Fish and Wildlife Service out into the woods to get it on hands or hands-on education about private forest landowners. Our goal with this listing and all proposed listings and listings that are in progress is to work towards collaborative conservation between Fish and Wildlife Service and private forest landowners. However, in the case of the black pine snake, we clearly understand that U.S. Fish and Wildlife is mandated to designate critical habitat when a species is offered protection under the Endangered Species Act. But we also understand that they're mandated to consider the best available scientific data when designating that habitat, and also to consider the potential economic impact of those designated habitat areas. In the case of the black pine snake, the data that was being utilized were sightings that were over 20 years old, and the assessment of economic impact was zero. This is why we felt we were obligated on behalf of our members and all private forest landowners who are in the range of the black pine snake to seek legal remedies to the designation of the critical habitat. We were very fortunate to be able to work with Pacific Legal Foundation. We have worked with them in the past on other cases, but never had the opportunity to work with them directly. And we're very fortunate and excited that we have the opportunity to work with them now to help seek a remedy to what we believe was an unjust designation of these habitats. I'm now going to pass it over to Jonathan Wood to tell you a little bit more about Pacific Legal Foundation, and then I'll join back during the Q&A session to moderate the question and answer. So, Jonathan.
Thank you, Scott, and to everyone who was involved in setting up this webinar. We really appreciate having the chance to speak to you and to your members. I just want to take a minute or two at the top to introduce Pacific Legal Foundation to anyone who isn't familiar with us. PLF is one of the nation's oldest nonprofit law firm dedicated to defending property rights and individual rights from government overreach. In our nearly half century of existence, we've won 12 cases at the U.S. Supreme Court, the majority of which involve federal and state environmental regulation that we believed and ultimately were vindicated in arguing went too far in restricting private property rights. For most of our existence, the Endangered Species Act has played a really big role in our work. And our guiding principle is the idea that an Endangered Species Act that doesn't respect private property rights will ultimately serve poorly both property owners and endangered species. Economists have long observed that if you use Endangered Species Act regulations to penalize landowners who accommodate rare species or provide habitat, you're going to create perverse incentives that ultimately harm species and their habitat. And so to give effect to that principle, and one of the things we do is to develop cases that demonstrate this underlying problem and try to establish precedent to tackle it. And right now, we're looking at cases like this one to build off two of our most recent victories. The first of which was that PLF led the charge to have Fish and Wildlife Service change the way it regulates threatened species. So previously, they essentially threw the book at property owners, limiting almost anything you could do on your land if you had a threatened species there. Under the recent rules that PLF championed, that the service will take a more hands-off approach and work with property owners to find a way to recover species and reward beneficial efforts without going too far and restricting property rights. And then the second recent victory is the Weyerhaeuser decision that I'm sure most of you are aware of. PLF represented the individual landowners in that case, and thus had a hand in establishing, one, that you can challenge critical habitat designations, but also that the service has to think through, okay, is this really habitat? Is this regulation really something that's going to promote the species recovery at considering the costs? And that we see this case as a natural way to build on that important win. And with that, I'll hand it over to Charles to tell us a little bit about this case.
Thanks, Jonathan, and thanks, Scott and Forest Landowners, for having us on today. So a couple of weeks ago, on February 26, PLF filed suit on behalf of FLA and several private landowners, Grey Skipper and the Goodloe family. As Scott mentioned, we're challenging the US Fish and Wildlife Service's arbitrary designation of critical habitat for the black pine snake. So for the next couple of minutes, I'm going to discuss the details of the designation and the claims in our lawsuit. First, I'm going to speak for a few minutes about the pine snake critical habitat designation, provide a little bit of context. Second, I'll explain the negative effects of critical habitat on private property rights and stewardship initiatives. Third, I'll detail the claims of our lawsuit and our next steps, and I'll illustrate how the lawsuit fits into a broader strategy, as Jonathan mentioned, to fight back against illegal and arbitrary actions by the United States Fish and Wildlife Service, actions that often harm private landowners and ultimately don't serve the cause that the Fish and Wildlife Service is tasked with. So early last year, the US Fish and Wildlife Service designated over 300,000 acres of land in Alabama and Mississippi as critical habitat for the black pine snake. I'm sure many of you are aware of the designation. This includes over 90,000 acres of private land, the vast majority of which is owned by forestry businesses and managed for timber production. A large chunk of this private land is located within two specific areas or critical habitat units in southwestern Alabama. These are units 7 and 8, which are the former Scotch Wildlife Management Area and an area adjacent to the Fred T. Stimson Special Opportunity Area, both in Clark County. Now, in designating these critical habitats in units 7 and 8, the service deemed both units to have been occupied by the pine snake. We'll speak a little more in a few minutes about what a finding of occupation actually means, but for now, it's worth noting that in determining that the private lands in Unit 7 were occupied by the pine snake, the service relied on a single sighting of the snake over the course of 20 years. In Unit 8, they relied upon 2 sightings of the snake in 23 years, and both of these sightings occurred on public land and not the adjacent private acres that were also designated. And it's worth briefly noting that a 2009 survey of the area, which now comprises Unit 7, conducted with the specific intention of locating pine snakes, failed to locate any individual snakes. The service even acknowledged the weakness of this evidence, but it claimed that despite the lack of credible sightings and recent sightings, occupation of the lands within Unit 7 could be inferred from the presence of longleaf pine habitat. So it appears really that the reason these areas were targeted by the service was because of the responsible management of landowners, such as our clients, the Skipper and the Goodloe families, who have voluntarily conserved longleaf pine on their property and participated in state conservation initiatives. Instead of rewarding these landowners, the service punished them with additional federal regulations. Now, I'm going to speak a little about how the Endangered Species Act operates and just a little bit of background about how it affects private landowners. This should provide some context for discussing the claims and purpose behind FLA and PLF's lawsuit and the role of strategic litigation in reforming the Endangered Species Act. So critical habitat can include habitat areas which are occupied by the species, areas where the species might be found at any given time, as well as unoccupied areas. However, the Act and its regulations require a far more onerous process for designating an unoccupied area as critical habitat. And one result of a recent victory in Weyerhaeuser a few years ago is that the ability to designate unoccupied habitat has been further limited by regulation. I mentioned just before that the Alabama areas were designated as occupied on the basis of isolated sightings of the Pinesnake. By taking the position that an isolated sighting over the course of several decades deems an area occupied, the service in effect finds a way around the stricter rules for designating unoccupied critical habitat after Weyerhaeuser. Now, occupied or not, once designated, critical habitat has numerous effects on private landowners, and these effects are exhibited well by the Pinesnake designation. Principally, any future use of designated land could be jeopardized. I'm sure many of you are familiar with the regulatory requirements under Section 7 of the Endangered Species Act, and the requirement that whenever one seeks a permit or federal funding within a critical habitat area, like a dredge and fill permit under the Clean Water Act or certain permits required for pesticide use, the designation will trigger greater scrutiny of that permit and ultimately result in burdensome limitations and costly mitigation measures. In the case of the Black Pinesnake, the service predicts that as a result of consultations involving the designation, it will recommend project modifications such as the relocation of activities outside of habitat deemed to be occupied and mitigation requirements such as the retention of downed logs in project areas. Additionally, in addition to these regulatory burdens, a critical habitat designation will immediately reduce the value of any private property because prospective buyers recognize that burdens flow from such designations. Quite rightly, they recognize the regulation that's associated with the designation and are unwilling to pay as high a price for the property. And there's now an increasing body of research which recognizes this phenomenon, this stigma phenomenon. However, when designating habitat for the Pinesnake, the service didn't actually analyze the potential reduction in value. It acknowledged that a reduction could occur, but it didn't properly consider or analyze this when it made its final decision. Now, as Jonathan mentioned in the introduction, one especially perverse outcome of the Endangered Species Act generally is that by imposing harsh regulations on land use, it treats endangered species as a liability rather than an asset. Landowners who are committed to habitat conservation and responsible stewardship often end up being punished for maintaining features that benefit endangered species. They're rewarded for their good deeds with additional regulation. And the Pinesnake designation exhibits this issue very well. The Skipper family had collaborated with the Alabama state government for 6 decades. They'd participated in the creation of the Scotch Wildlife Management Area. They'd opened their property to the public and to the government, and they'd opened it for research and recreation. But because they voluntarily maintained longleaf pine on the property and engaged in these conservation activities, they now find themselves subject to this critical habitat designation, in effect targeted for their good deed. The service has acknowledged that a majority of listed species rely on private property rights for their survival. But because the federal government often believes that it knows better than people who own and manage their property, we frequently see arbitrary actions like the Pinesnake designation. Now, as Scott mentioned, he mentioned a few of the requirements in his introductory remarks. Congress wasn't willfully blind when it passed the ESA. The statute actually mandates that critical habitat designations be based on the best scientific data available and that the service assess regulatory costs and benefits when making a decision. And Congress, in fact, expressly authorizes the service to exclude any areas of critical habitat if the benefits are outweighed by the costs. And after the win in Weyerhaeuser back in 2018, these decisions are now reviewable in federal court. Additionally, there are other statutes passed by Congress which are designed more generally to rein in the power of executive branch bureaucrats. One statute which is particularly relevant to critical habitat is the Regulatory Flexibility Act, which requires an assessment of impacts to small businesses and for any agency to consider alternatives that would be less burdensome to small businesses when it's making a regulatory decision. Unfortunately, when designating critical habitat, the service often ignores and minimizes these requirements. The black pine snake designation is no exception. The service refused to meaningfully consider costs to forestry businesses and did not exclude any areas from the final designation. And this is where the importance of strategic litigation like FLA's Pinesnake lawsuit comes into play. By suing to enforce the requirements of the statute, we can set favourable precedent to ensure impacts to private landowners are properly considered in the future. So with that context in mind, I'm going to spend the last few minutes now just explaining the specific claims alleged in our lawsuit and discuss how they fit into a broader effort to reform the ESA and protect private property rights of forest landowners and other private landowners. In short, our lawsuit alleges that the service's designation of the 2 Alabama critical habitat units was illegal because it was based on insufficient scientific evidence and did not properly consider economic impacts to private landowners and forestry businesses. We allege 6 claims. In our first claim for relief, we argue that the service's designation of the 2 Alabama units was not supported by the best available science, but instead rests on unreliable speculation about the pine snake's occupation of these units, i.e., a single sighting in over 20 years. We argue, and we intend to argue, that intermittent and isolated sightings over long periods of time can't support a finding of occupation. What we're trying to do is we're seeking to enforce the plain meaning of the term occupied as it's set forth in the Endangered Species Act and set precedent to prevent the service from using this kind of scant evidence to designate large areas of private land in the future. Alternatively, in our second claim for relief, we argue that the service did not make the more demanding finding required to determine that this unoccupied area could still be habitat. These 2 claims build upon PLF Supreme Court victory in Weyerhaeuser and our 10th Circuit victory in New Mexico Farm and Livestock Bureau. Our goal is to enforce greater limitations on the service's ability to use an unreliable evidence of occupation and habitat suitability to designate land as critical habitat. In our third and fourth claims for relief, we focus on the insufficient economic analysis that was performed. We challenge the inadequate economic impacts analysis by arguing that because the service concluded that the designation would have a minimal economic impact on timber and forestry businesses, the service essentially illegally sidestepped Congress's requirements that it thoroughly analyze and justify the costs that designations impose on private landowners. In our fifth claim for relief, we argue that notwithstanding the service's inadequate economic impact analysis, it still estimated significant impacts in the form of property value reductions. It did acknowledge that the stigma or perceptual effects phenomenon I just spoke about a few minutes ago exists. And it estimated that there could be potentially tens of millions of dollars in property reductions, but it didn't actually analyze this. We argue that even on this inadequate evidence considered, the service's decision not to exclude any private land from the designation was arbitrary and illegal. And this claim follows on from Weyerhaeuser, as in Weyerhaeuser, the Supreme Court, for the first time permitted judicial review of an inadequate economic exclusion analysis. These claims, which relate to the economic analysis, are generally part of a larger effort to combat the service's refusal to acknowledge the significant real-world effects of critical habitat on businesses and landowners. We want to ensure that in the future, a meaningful economic analysis is performed whenever habitat is designated, and that the service only designates habitat after adequately considering impacts to landowners. Now, just finally, in discussing our claims, we also allege a sixth claim under the Regulatory Flexibility Act. The service has made a habit of refusing to consider impacts to small businesses under the Regulatory Flexibility Act when designating critical habitat. It basically claims that this type of action is exempt from the Act. We think they're incorrect about that, and we want to take on their routine refusal to assess impacts to small businesses. With all of that in mind, I'm just going to wrap up by discussing the next steps in the lawsuit. We filed the complaint in the U.S. District Court for the Southern District of Alabama in Mobile on February 26th, or a few weeks ago. We've now served the complaint on the defendants, and we expect a response from them at the beginning of May. Based on that response, we'll then brief and argue the issues in the case, which is a process that could take a year or two. Now, if we are successful, the relief we've requested is for the court to vacate the designation and remand it to the service to be redesignated according to the best available science and taking into account the true economic impacts of this action. But more broadly, we hope that this lawsuit will secure the rights of property owners and limit the ability of this service to impose arbitrary and illegal critical habitat designations into the future. So thanks again, Scott. We appreciate you all having us on here, and Jonathan and I are happy to take any questions now.
Thank you, Charles. That was very helpful, and I think what you said there at the end is it really summarizes why we felt compelled to get involved here. Is we see the injustice that happened here in the critical habitat designation in Alabama, but it's far-reaching for all members. We can't let this continue to happen where arbitrary designation happens for critical habitat across the country. I mean, with the amount of species that we have in the pipeline right now for proposed protection, this could really get out of hand. So I really appreciate you guys getting involved. Katie, I believe we were going to do an order of. Do we have any hands raised, or just this one question I see in the box here?
Yes, we have Margaret Harden. And I have unmuted you, Margaret, on our end, but I think that you also have to unmute on your end, and you can go ahead and ask your question.
Okay, it's been a couple years since I've been able to join you guys for reasons. But I just remember a couple of times when we were there, you actually had members of U.S. Fish and Wildlife there to answer questions, and we seem to be entering into fruitful discussions. So I sort of have a couple of different questions here. First of all, how have things changed so much that the discussions are no longer fruitful and that litigation seems to be the best way to go? Second of all, so I was actually looking through the designation, and they talk very specifically about how a lot of the specific management guidelines have been scaled back to allow sort of most normal timber management actions, which, as you pointed out, these people are doing a good deed by managing their property well. So they are encouraging healthy wildlife occupation. So I'm confused as to how land values are affected if normal forestry activities are still allowed. And I mean, this includes herbicide treatments, prescribed burning, thinning, I mean, all of these sorts of things. So you're talking about that this is punishing them if they're designated this way, but it doesn't actually seem to be impinging upon their ability to use the land like they were going to anyway. So my final question is, what is this costing us as the FLA to pursue this action? And what will we really get out of it as opposed to the discussions we used to engage with Fish and Wildlife?
Yeah, great questions. Great to hear from you. I hope you guys are all doing well. Let me start at the top there at your first question. So about the discussions we've been having and the relationships that we have been building. I'm happy to report that our discussions are more fruitful now than they have ever been before. A lot of that is thanks to Lauren Ward and the work that she's been doing with FLA and the service. I will tell you that the way the service designates habitat and the way that they write the rules on the listing of species is a little tough to follow. It's been a learning experience from us. There are things that are out of control of the region office. There are things that are out of control of the field office. There are things that are out of control of the DC office.
Okay, when you say out of control, that's a very general term. What do you mean?
There's not a very clear chain of command is what I'm trying to say, is that species status assessments are done in the region. The listing of the rules written around the species, the initial rulemaking comes out of the field office. So it's just not a very clear chain of command of how these listing processes happen within the service. So there are those in the region office that will tell you that they don't agree with what happened, the rules that came out of the field office. There are those in the DC
So
office.
it feels like what you're really looking for is a more regularization of rules, and so
I don't know if
Yeah.
I'd characterize it that way. This is an instance that I would say, like with the Louisiana pine snake, we're not dealing with the same issues here. Um, this is a very unique case but one that we believe can be replicated. So our discussions now have been, I think, more fruitful now than ever. I want to jump to your second one real quick, and the management guidelines are not really a concern, and we don't really see a lot in really heavy-handed management approach here. Where the concern happens is when you create a federal nexus, or you go to engage in certain activities, like Charles was saying, like applying for a permit, like herbicide applications, things along these lines. Those do get impacted. So land values is, and I'm jumping to your
But it
third.
says right here that herbicide treatments, prescribed burning, thinning, and longleaf pine restorations are all not affected.
I don't know that I mean, that's a very black and white reading, I believe, of the regulations, and it doesn't always work that way. I would just see if Jonathan or Charles wants to jump in and
Like
try to.
it seriously says here on the timber management activities exempted and decision on critical habitat delayed to 2016. Like it's the government document. It specifically calls out those
Well,
activities.
government documents have interpretations too, and they get interpreted at the field level. So I don't believe for a minute that what we read in black and white is exactly how it gets interpreted when activities are being permitted. And let's give a second for Jonathan or Charles to jump in.
Well, I'll jump in and to answer the how much is it costing question two.
Yeah.
Just to note that PLF is a nonprofit law firm, and thanks to the generosity of our donors, we represent all of our clients for free. So this litigation isn't going to cost FLA or any of the individual landowners anything to actually litigate. As far as your more specific question about this rule, the Fish and Wildlife Service is conflating two different types of rules. It's true that under what's called a 4D rule, and I mentioned earlier how PLF was involved in getting reforms there, that a lot of forest practices are exempt. So you won't need an ESA permit if your activities would cause take, if they're exempted under the 4D rule. But that's a separate question from whether you would need other types of federal permits. The 4D rule can't authorize you to do something that would require a permit under the Clean Water Act or other EPA regulations. And that's where the critical habitat designation comes in. Whenever EPA gives a permit like that, or any other agency gives an individual landowner a permit for activity in critical habitat, it then has to go to the Forest Service and work out a way to mitigate the project. And that's where Fish and Wildlife Service came up with the estimate of the tens of millions of dollars in potential mitigation that this designation may ultimately lead to. And as you know, we're not challenging the 4D rule, as I think Scott was getting at. Our litigation is limited only to the critical habitat designation.
Right. I want to, Mark, thank you for your questions. I appreciate it. I do want to make sure we jump to some other questions here. And we have one from Brian that asks, what is the practicality of pressing a Fifth Amendment takings claim in this case? And I don't know, Charles, can you see these questions? Are you able to read Brian's question here? Do you want to address that?
Jonathan's got some pretty good background on the specific question, because we've considered the context of Fifth Amendment takings over the years in our ESA cases. And Jonathan's been privy to a lot of those decisions and has written a little on that subject. So he should have a good answer on that one.
Yeah, I mean, the basic answer is that it's a good point to make when in negotiation with the service, when you're trying to shape an eventual critical habitat designation. But in terms of litigation, courts would say it's premature here. Courts prefer to wait for landowner to apply for a permit, find out what kind of mitigation will actually be imposed. And at that point, you may have a Fifth Amendment claim. So right now, the only thing the landowners can do is the ESA claims that we brought in the case.
Yeah, and I know we're, thank you, Jonathan. I know we're not, Jonathan pointed out very well that we're not challenging the 4D rule here, but I want to jump to this question just because it's on the line of thought from the first question from Margaret that Leela Kelt has here, that if we want to change the management to loblolly pine, say from longleaf, and you're in the, I'm assuming Lee's saying that this would be in the critical habitat area. Let's say Lee's a landowner in the critical habitat area and he wants to change from the management to loblolly pine, stop any future prescribed burning, and wants to stump the area after the longleaf is cut. I mean, this kind of gets into the area that stigma, right, Charles? Is that? I mean, I know it's a clear stigma if you have a land sale, like two pieces of land, all things being equal. If one has critical habitat designation and the other one does not, that clearly, I believe, is where the stigma lies. But I believe there's a stigma with the ability to manage as you see fit and is proper forest management. Um, that exists as well, right? I mean, I don't believe you could undergo these activities without consultation.
So if they required any kind of federal permit, consultation would be required. But this question also gets at a specific issue about this designation and the way that it designates a large area as occupied by the pine snake. So in effect, a prudent landowner would have to assume that given the area has been designated as occupied, that there may be individual snakes in the area. And this gets back to the issue Jonathan was mentioning, kind of between the interplay between the 4D rule and the critical habitat designation. A prudent landowner would probably want to be very careful about performing those kind of activities in an area designated as occupied critical habitat, even if they don't require a permit from a federal agency. Because if they were to, inadvertently commit harm the species accidentally in the process of converting from longleaf to loblolly, they may have problems under the 4D rule. So it goes into the stigma issue a little bit in the way that this has been designated. And going to the question of stigma as well, that's just a more general, that doesn't often stem directly from the regulatory encumbrance at play. The stigma more generally results, the perceptual effects we're discussing, results from biased perceptions about what a critical habitat designation could mean in the future, the significant restrictions that might be placed on development or any other federal permits. So it doesn't necessarily flow directly from the specifics of the rule itself. It's a more general sort of perception or stigma. And there's been an increasing amount of literature written on the subject, which we'd be happy to share with your membership.
Thanks, Charles. And I think Gray has a question here from Gray Skipper asking us to elaborate on the sightings in critical habitat unit number 7 versus the acres in the area. I'm not as familiar with what the acreage size is in that area. Does someone have that, and versus how many sightings we've seen?
Yeah, that's a very good question. So I believe the Unit 7 is a designated area of 33,395 acres. Within that area, there's been one snake sighted in the past 20 years. And it's also worth noting that the service did include scientific data about sort of the maximum range that a pine snake might roam. And the maximum I think ever recorded is about 900 acres. So a single sighting in 20 years in 33,000 acres is wildly disproportionate to the scientific data that the service has itself cited.
Yeah, so James, I think we just answered your first question, and you were asking your second one about is there any reliable count on the number of snakes affected, and I think it would be 0 right now to our knowledge. I mean, because we don't believe the area is occupied. I would be quick to say that the presence of a certain tree species and soil type does not habitat make, but I've heard it once from U.S. Fish and Wildlife Service, and I believe it's a belief across most of the agency that just because you don't see it doesn't mean it doesn't exist. And that's real tough. That's tough when you're talking about issues like this about what is occupied, non-occupied. Katie, do we have any hands raised?
No, not at the moment.
Okay, we have one other question from Chris here. How large an area, about how many private landowners this impact? Charles or Lauren, do you know? I know I've looked at the maps and ownerships, but I'm not sure what the exact answer is. I know it's 90-something thousand acres of private land in the areas of the total areas, but I'm not sure the number of landowners.
Yeah, so I believe that the entire private area designated is 93,000 acres or so. I'm not sure how many private landowners are affected within that area. We looked at plat maps and we were developing the case, but I'm not sure the exact number of landowners.
I know Gray has an idea because I know he sent mailings out to him. I would venture a guess that it's over 100. I know that 100 is a safe number, but I'm almost certain it's over 100. It looks like we have come to the end of our questions. We're definitely at the end of our time. I would like to thank everybody for participating today and encourage you, if you have a question that comes up that you weren't able to ask today, please reach out to us, and we'll be happy to get back to you and answer your question. We hope you will join us on future webinars. We have one coming up here soon. Katie, our second part of the first 100 days of the Biden administration will be, when is that? March 23rd. Am I right on that date?
Yes.
And please watch your email, and we encourage you to join us for that webinar. I want to offer my thanks to the Pacific Legal Foundation for all you're doing for private forest landowners across the country. Thank you, Jonathan and Charles, for your time today. And we wish everybody good health and safety during these times. And we look forward to seeing everybody hopefully in person soon. Thank you for being here today.